Okay, well, it's 9 o'clock, so I think we'll get started. Welcome back, everyone, to our 2026 Student Rights Conference. My name is Mark Weicker. I have short brown hair. I'm wearing glasses today, and I have a light gray blazer, a white shirt, and a red tie. Today is day 2 of the conference. As I mentioned yesterday, the conference is co-hosted by Abdnour Weicker and MyPAC, the Michigan Parent Advocate and Attorney Coalition. We had a really engaging first day, really learned a lot. We had 6 total sessions, a very engaging and interactive Q&A, which was great. We had a great panel discussion at the end of the day, which was also great. We were especially glad to see so much engagement by the attendees, so we hope that continues. We had 57 questions yesterday asked and answered through the Q&A, and not counting some of those that we had received by email, so that's great. So thank you very much for the attendees for the very thoughtful engagement. Very good questions too yesterday. We hope to have a similar level of engagement today. I think it makes the presentations better. Just a few reminders before we jump into the first presentation. The conference is intended to be accessible and interactive. You'll see at the bottom, or there is available at the bottom, a closed captioning button, which can be used by any individual attendee. I talked about the Q&A feature. We do like to use that instead of the chat. You can ask questions throughout the presentations on the Q&A, and for each presentation, we have 2 assigned attorneys to answer questions for every session. If a question can't be answered by the assigned attorneys, we try to pose the question to the presenter at the end of the workshop, end of the session. We'll have about 5 to 10 minutes at the end of each session for questions. For those of you that submitted questions that were unanswered, we'll try to get those to the presenter. And just like yesterday at the end of the day, we'll also have a Q&A panel. So if questions don't get answered at the end of the sessions, we could answer those during the panel. If you have a state-specific question, please do put the name of the state in your question, and we'll do our best to answer that. Do that as well. You may notice that the webinar is being recorded. The recordings will be made available for all the attendees here on the main conference page. So that's lawyersforstudents.com/SRC. And we usually do that within 7 days after the conference. We will pause the recording at breaks and at lunch. The handouts are available just like yesterday at the same location. That URL, lawyersforstudents.com/SRC. The handouts, if you look at the title of each of the sessions, the handouts are available through a link right next to the title. We'll take 10-minute breaks on the hour, at the top of the hour, and we'll ask you to complete a session evaluation before you go on the break. We do attendance verification at the end of the day. This is submitted for CLE credit. It's also an evaluation, so it's a whole day evaluation for day 2. So we would like you to complete this even if you're not seeking CLE credit. We'll give you the Ohio Supreme Court activity code too at the end of the day when we finish that, when we complete that evaluation. We'll have poll questions throughout the day, and we'll announce when they are posted. We'll try very hard to stay on track. I think we did a really good job yesterday. And we'll give speakers a 10-minute warning, which is an indication just to wrap it up and get ready to take some questions. And then we'll cut the speakers off when their time is up. So we want to stay on time, and we'll do our best to do that. I think that covers it for me. In 1 second, I'm going to turn it over to my friend and law partner, Liz Abdnour. But before we do that, we're going to start with a poll question. What category best describes you? In what role are you attending the Student Rights Conference? And once that wraps up and we share the results, like I mentioned, I'm going to turn it over to Liz Abdnour, who's got a presentation, Student Rights in 2026, Case Law Update. And once this is done, Liz, you can get started.
Great. I'm not sure if I know when we're done, so just let me know.
Yeah, it looks like most everyone has entered. Let me see if I can share these. All right. Now everyone should be able to see the results. 38% attorney, 10% parent guardian, 43% advocate, 14% student, and about 5% other. Oh, nice mix. All right.
Great.
On to you, Liz.
All right. Well, good morning, everybody, and thank you so much for being here with us. We had a really great set of sessions yesterday, and hopefully everybody's got their coffee because I'm going to hopefully get everybody woken up with some exciting and or unexciting litigation updates here. Next slide. So what we're going to talk about today is we're going to talk about recent litigation that's happened over the past year that's related to the civil and constitutional rights of students in education. And when possible, I'm going to give everybody my thoughts on how we can address some of these changes, if there are any compliance obligations that schools have related to some of these cases, and strategies that you can use if you're coming up against any of these issues. Next slide. So the first couple of cases we're going to talk about are related to the First Amendment to the U.S. Constitution. And for anybody who was with us yesterday, Nicole did a fantastic presentation giving you some background on what students' rights are in school with respect to free speech. We're going to talk a little bit. One of the cases we're going to talk about references the Tinker case, which Nicole spent a lot of time on yesterday. And just as a refresher, the First Amendment prohibits any government entity, which includes schools, from abridging the freedom of speech of students. Also, the right to assemble, which touches on the point that Mark made yesterday about students being able to participate in walk-ins if they choose to do so. And we're really going to be focusing today. I had tried initially, I was trying to incorporate some higher ed cases in my presentation, but really the big hits this past year were K-12 cases. So there's only going to be a couple of higher ed cases that we're going to talk about, if any. Actually, now that I'm thinking about it, I might have cut the ones I had. So we'll see. Mystery to be solved later in the presentation. So, okay, if you can go to the next slide. So the first case I want to talk about is Oswald v. Lakota Local School Board. This was a case that came out of the Southern District of Ohio with Lakota Schools, which is down a little bit north of Cincinnati. This was a case involving someone who had come to speak at a number of public board meetings. Next slide. So Brian was a member of the public who was attending school board meetings and just giving his opinions during the public comment period. He had comments that he wanted to make about critical race theory, and he had concerns about the school district's COVID-19 mask mandate. There was a rule with the school board meetings that when someone was presenting during public comment, they needed to speak towards the board members, like so to face and to direct their comments to the board members who were sitting up at the front of the meeting. Oswald repeatedly refused to follow this rule, and he was not facing the board members. He was turning and facing the audience members. And so he was repeatedly asked to turn around, face the board members. This was a rule and a policy that they had in place for these meetings. And ultimately, at one of the meetings, received 6 warnings until ultimately the board asked a law enforcement officer to escort him out. So the question is, was this board policy, which required people to face the board and for which Oswald was removed from the meeting, a violation of the First Amendment. Next slide. So, so initially the case went to the Southern District of Ohio, and then the case made it to the Sixth Circuit. We spent a lot of time talking about the Sixth Circuit yesterday. So the Sixth Circuit ended up determining that because this policy was content neutral, meaning that it wasn't reliant upon any sort of specific viewpoint or statement that an individual was making, and because it applied to everybody, it wasn't specific to, certain groups of people or anything like that. This policy was not a First Amendment violation. So when they were analyzing the decision, they determined that a school board meeting is what's called a limited public forum. So there's different types of public forums that case law provides for. Some are just totally open public forums. And so that would be something like a public square or, a park or some sort of area where everybody is always allowed. It's a place that's for the public. Taxpayers generally pay for it. And you have the broadest First Amendment rights in those arenas. A school board meeting is a limited public forum. So it's not a place that the public just goes all the time whenever they want. It's open to the public at certain times. School boards can have meetings that are open or closed. They get to choose what the location is. They get to choose what the hours of the meeting are going to be, that sort of thing. And so because of that, there's more room for someone who's running a school board meeting to determine what's going to happen in those school board meetings. So what the court determined that because this was a limited public forum and because the rule about needing to face the board was a rule that was applied to everybody, any member of the public who chooses to come in, it's not based on what you're happening to choose to present on. And because it serves a significant government interest, which is another analysis when you're talking about constitutional claims, then it was not a violation of his First Amendment rights. So another consideration that the court looked at was whether Oswald would have had any other opportunity to speak directly to the public instead of the board if he wanted to. And they determined there's lots of other ways for him to do that. So if he wants to speak to members of the public, it kind of doesn't even make sense really to go to a board member and more board meeting and do that. Maybe you want to schedule a public meeting for people to come. Maybe you want to post on the internet. Maybe you want to write an op-ed. Perhaps there's a PTA journal that you could get to publish something in, something like that. So he was going to be able to express his viewpoints to the public in a lot of other places as well. So that was another consideration here. So ultimately, you're allowed to have rules about how speech is made as long as those rules apply to everybody, don't depend on exactly what the person is saying or what their topic is, and when it's in this limited public forum. Next slide. Okay, so the next case was a case involving a group of parents who called themselves Defending Education. And they had brought litigation against the Olentangy local school district, which I think is near Columbus, if my Ohio geography is still sharp enough. The case originally was heard in the Southern District of Ohio again as well, and then went up to the Sixth Circuit. Next slide. Awesome. Thanks, Renee. Okay. So this was a case, it was a very interesting case, and it's a case that we're seeing this issue pop up really kind of across the country right now. So the school had implemented a new sort of harassment and bullying policy. And one of the provisions that the school included in this policy was that students were not allowed to intentionally use pronouns towards other students if they were not their preferred pronouns. So, this is a situation where You'll see my pronouns. You can probably see my pronouns in my name identifier here. So most of you are probably familiar with this. People may choose to identify their pronouns. Some people because their physical appearance may not match or may be difficult for people to identify what their gender identity is. Other folks may choose to identify their pronouns just to sort of try and make it more commonplace for all of us to be identifying our gender pronouns. And so if a student had identified preferred gender pronouns, the school determined that it was going to be a component of their harassment policy that if another student used incorrect pronouns or misgendered someone, that that was going to be a violation of the policy. So this group of this group of parents defending education, they felt that it was a violation of students' First Amendment rights for them to be required by this policy to use pronouns that may not match their classmates' biological sex. So their argument was that students had a First Amendment right to use the gender pronouns that they felt comported with other students' biological sex, even if those pronouns were not how that student had identified their gender identity. So, in response to an initial concern that was raised by that group, the school issued a clarification that said that, look, we're not forcing any type of speech here. Students don't have to use preferred pronouns if they don't want to, but if they don't want to do that, then they just need to avoid pronouns. So, if there's a student who uses she, her pronouns, and another student feels that those pronouns don't align with their biological sex, of course, putting aside all the questions that I at least have in my head of how a 10-year-old might know what another 10-year-old's biological sex is without engaging in sexual assault, put that aside. But let's say the other student doesn't believe that the she, her pronouns align with the other student's biological sex, then the solution is to just not use pronouns. So just, ways to get around that are use the person's name. You could say they, them. You could say that person. You could say that student. There's a lot of options. So there were two issues that the court was looking at here. So first, what the district asserted was that they were, or what the defending education asserted was that there was a First Amendment violation because the district was prohibiting speech addressing matters of significant public concern. So again, this question of the use of gender pronouns in schools, it's a big one. It's something that's coming up nationally. It's in the news. They're arguing that this is a significant public concern. This is something that students should be able to use pronouns about, or should be able to choose what pronouns they're using for others. Second, was it discriminatory against students based on the students' viewpoints? Next slide. So what the court held, and relying on the Tinker case that Nicole discussed yesterday, was that the policy did not violate the First Amendment because the school had made a reasonable analysis that they needed to prevent disruption and protect students' rights, meaning their right not to be harassed or discriminated against based on their sex through their gender identity. And the analysis was that because, first of all, schools have a little bit more room to regulate speech when they have concerns that the speech would materially and substantially disrupt school activities or infringe the legal rights of others in the school community. So, this is why, for example, schools can make rules that students can't wear T-shirts to school that have profanity all over them. Or that, schools can make rules that students can't walk through the halls, just showing their middle finger, or, watching pornography on their cell phones in class, or things like that. It's important in our schools that they be, a place that all students are able to come to learn, and that people who are coming to school are not immediately exposing them to violations of their legal rights. So that was essentially what the school determined. And again, the really one of the critical components of the analysis here for the court was the fact that the school was not saying proactively, you must use the gender pronouns that the other students are requesting. So they weren't forcing speech. They gave the opt out. They said, great, no problem. If you're not comfortable using somebody's chosen pronouns, that's your decision. That can be based on, any sort of viewpoint that you have. And, we're not even going to inquire into that. The solution is just don't use pronouns. So we're not going to make you say anything. We're not compelling you to say anything. You can just choose to opt out of pronouns if you want to. All right, next slide. Okay, so the next case, we just got one of these, addresses the Fourth Amendment. So the Fourth Amendment is, it addresses the right for people to be free of unreasonable searches and seizures. And again, we talked about this yesterday. I can't remember who, but somebody had raised when we were talking about, I think it was Megan, when we were talking about things people might not realize are legal or illegal in schools, that it is totally legal for schools to search lockers. And so again, this question of what is an unreasonable search and seizure is a question that come up sometimes in schools. And the analysis is a little bit different at school than it would be in your home because it is a place where, again, schools have to keep young people safe. And so there's a little bit of a higher level of ability to engage in searches and seizures. Next slide, please. Okay, so this one came out of Michigan. It was two parents, and I do not know how to pronounce their name. I've been calling them Halas, so hopefully that's right. I'm sorry, Halas family, if I'm butchering your last name. They brought the case on behalf of their son against Cass City Public Schools. This case started in the Eastern District of Michigan and went up to the Sixth Circuit as well. Next slide. Okay, so again, I think Megan was talking a little bit about the Oxford shooting, which I know everybody, I think, in Michigan is familiar with. I bet many of you in other states as well heard about it. Very, very tragic and painful school shooting here in Michigan. The student had, I think, somewhat of a troubled home life, had brought a gun to school. Unfortunately, very unfortunately, in that case, he had been demonstrating some signs of distress in school. If I'm remembering right, I think he even drew a picture of a gun in school. He was called into the office. He was questioned. No one actually searched his backpack. He was let back to class, and then he ended up starting a shooting rampage and ultimately killed 4 students at the school. So this had happened. The Oxford shooting had happened very recently. The decision was issued in 2025, but I think the case started in 2021 or 2022 in the Eastern District. So this Oxford shooting had happened very recently. So HH was at school. Cass is not too far from Oxford. It's about 60 miles south. And he made comments at school about having brought a gun to school. School and teachers and administrators obviously were in extremely high alert, like even more so in Oxford than in other situations because of this component where the Oxford student had been brought to the counselor's office. They talked to him. They didn't search his backpack. He was allowed back to school. So there's a whole set of questions about liability that arose. There was a bunch of litigation. Ultimately, the litigation was not successful against the school because the courts determined that the administrators had done their due diligence, at least, which is kind of a low bar. But very, very high alert. Those cases had not all been decided yet. And so administrators were just like, we cannot even allow a possibility of this happening at our school. So HH was brought down to the office. He was questioned. He was also searched, unlike the student in the Oxford shooting. However, and as we'll see, I'm a little, I'm not sure I understand why this issue even came up, but it did. He was not provided with any notification of his Miranda rights. So those are the rights that we always see on TV. You have the right to stay silent. Anything you say can and will be used against you in a court of law. You have a right to an attorney, blah, blah, blah. Those rights attach in criminal situations. But the attorney in this case, representing the family, made the argument that they should have attached here as well. So anyway, after the search, the school determined that he did not pose any immediate danger to students or staff. However, he was still referred for an expulsion hearing because he made the threat about bringing the gun to school. At the expulsion hearing, there had been a law enforcement investigation which determined that law enforcement was not going to proceed with any criminal charges against HH, and the superintendent did not notify the board during the hearing of the outcome of the law enforcement investigation. And so the school district, the board then determined that they were going to expel HH due to his threat of violence, which was something under their policy that they're allowed to do. So the questions in this case was first, did the search and seizure violate the Fourth Amendment? And second, did the district's failure to provide HH with a Miranda warning and the superintendent's failure to disclose the outcome of the law enforcement investigation, excuse me, violate HH's due process rights, also under the Fourth Amendment? So what the court determined was HH had not been subjected to an unreasonable search in violation of the Fourth Amendment, and that he was not entitled to receive Miranda warnings. And also, as I'll get to in a minute, that there was no violation of his Fourth Amendment rights by the superintendent not disclosing the outcome of the law enforcement investigation. So what the court determined was that because you do have more limited privacy rights at school, based on HH's statement that he was thinking about or was planning to bring a gun to school, there was a serious safety concern, which the school had, reason to believe might be something that could affect other students at the school. The places that they searched were all places that the student could have held a gun. So, it wasn't like the school, went to his house or something like that and was like, we're going to knock on the door and try and look in your house. They weren't, this is going to sound a little weird, but they didn't do like a cavity search to try and find a gun. They were searching backpack. I can't remember in this one if they searched a locker or not, but these are all places that, if a student were to bring a gun, would be places that one would expect that might happen. And during the search, the school officials tried their best to maintain HH's privacy, meaning they did it in a private area. They weren't alerting anybody that wasn't on a need-to-know basis about it. The court also determined that there was clear justification on the school's part to question and search HH about his comments. He had obviously made them. He didn't deny that he made them. There was a witness to the fact that he made them. They're concerning comments. And in terms of whether he was provided his due process with respect to the hearing and the Miranda warnings, the court determined that you're not entitled to receive Miranda warnings when you're being questioned and investigated at school. That's obviously, it's for criminal settings. It's for a criminal investigation. That's not what this was. And in terms of whether the superintendent had a right to affirmatively disclose anything from the law enforcement investigation, the court determined that he did not. The notice and the hearing before the board is what's required by Goss v. Lopez. So that's sort of the initial case we have that provided students with very basic rights to some type of hearing before they are deprived of their right to an education. It's very basic. You've got to get a notice and you've got to have some type of a hearing before the board, and that's it. There's no requirements about what the school does or doesn't present at the hearing. There's no requirements about what the student can or can't present at the hearing. It just has to happen. And so because those requirements were met, there was no due process violation, so the expulsion was upheld. Next slide. All right, we've got one Title IX case here because anybody was here yesterday at the end of the day heard me say that Title IX is dead, but we do have one. So Title IX, and Jess talked about this pretty extensively yesterday. It's a federal law that states that uh, if you are a school that receives any sort of federal funding, you are not allowed to discriminate on the basis of sex. Next slide. Oh, yeah, there we go. Okay, so this one came from northern Michigan, the Upper Peninsula, Escanaba area public schools. This case was heard in the Western District of Michigan. The plaintiffs were Chloe Allen, the student, and her mother, and Escanaba area schools was the defendant. Okay. So Chloe was a high school senior and she was interested in playing on her school's high school hockey team. And so she had initially attended one of the days of tryouts, but then she missed a couple of additional days because she was sick. She asked to do a makeup tryout, and the coach said no. Then, when she couldn't participate as an actual player, she asked to join the team as a practice player or a team manager. The coach also said no. She and her mother then filed a Title IX complaint with the district. The district did an internal Title IX investigation. The outcome of that investigation was that there was no violation of the school's anti-discrimination policies and no culture of hostility in the hockey team towards female hockey players. And the reason that analysis is important is because one thing to know about this case is that there had been two female hockey team members in the past. I'm sorry. So the issue here was, did the school violate Title IX by denying Chloe the opportunity to try out for the varsity hockey team due to her sex? Next slide. Okay. So this decision was made on what's called a motion for summary judgment, and so or was it a motion to dismiss? I actually can't remember, but I think it was a motion to dismiss because I think they were asserting the school was asserting arguments about what was in the complaint itself. So an important consideration when you're making a discrimination complaint is you have to be able to say that if I'm alleging discrimination based on my sex, based on my disability, based on my race, that was the only reason that this was happening. In this particular case, the coach had told Chloe that he didn't believe that she was ready to be on the varsity hockey team. And I can't remember if that was because of the initial day of tryouts or if he had seen her play before. And so the rationale that he gave her, true or untrue, the rationale that he gave her was that, look, I'm not making this decision because you're female. I'm making this decision because you're simply not at the performance or skill level that you need to be at in order to be on this team. Then there was also a claim that Chloe made separately under Michigan's Elliott Larson Civil Rights Act, which I talked about a little bit yesterday. That's the law that provides us with, in addition to legal claims that we can bring in court, an administrative process that we can file administrative complaints alleging discrimination or harassment in Michigan for an investigation. And the court determined that there was also not sufficient evidence for a jury to find discrimination here because in this case, the claims that Chloe was bringing were against the athletic staff and not the school district itself. And in this case, the only defendant that Chloe had named was the district itself. There's a history in Michigan with respect to these sex discrimination claims and really all discrimination claims that plaintiffs can't argue that it's the district's fault for the actions of their individual employees. If you want to implicate the individual employees, you've got to bring the claims against the individual employees. It's what's called vicarious liability. I think Mitch and Jacqueline discussed it a little bit yesterday with the Al-Zadani case. Essentially, that if you're claiming that something was discrimination by an employee, the claim has to be brought against the employee. So that claim was not going to be able to move forward. Now, this case is really interesting because what the court did in analyzing whether the discrimination was based on Chloe's sex or not is they applied the McDonnell-Douglas burden shifting framework, which is it's an analysis. It's a three-step analysis that's traditionally used in Title VII employment discrimination cases. And so the McDonnell-Douglas framework, what a court is analyzing there is that when an employee is alleging that they've been discriminated against under Title VII, or other statutes that might apply to employment discrimination, the court does a three-step analysis. First, has the person established what's called a prima facie case of discrimination, meaning is there an assertion of some type of discrimination on its face? The burden then shifts to the employer to prove that they had a reasonable employment or business-related rationale for the action that they took. And if the employer is able to prove that, then the burden then shifts back to the employee to prove that the employer's asserted reason, the reason that they're saying was their reason for taking the action, was pretextual or fake, right? Like made up. So here, the court said, look, this is a discrimination case. We haven't historically applied the McDonnell-Douglas analysis to Title IX cases, but we think it makes sense here. Because Chloe's asserting that this was discrimination based on her sex. She's asserted a prima facie case of discrimination. The school is now asserting that they had a reasonable, I guess, team or athletic-based rationale for not allowing her to try out or be on the team. And she has not been able to demonstrate, or she didn't demonstrate in her complaint, any sort of pretext, meaning any sort of explanation for why the school's rationale would not have been true. So for the exclusion, the claim that she had been excluded based on her sex and that was discriminatory, the school determined that they were dismissing that claim. She also had, and I didn't want to get into it because it's really complex, but she also had a claim that she was subjected to a disparate treatment based on her sex. The problem with that, and this is something that comes up a lot, I speak to a lot of clients about that, is that if you've got other members of your protected class who were not discriminated against, you don't have a claim there. And so because the hockey team had previously admitted 2 girls onto the team, that was sufficient to demonstrate that girls were not being excluded based on sex across the board as a matter of disparate treatment from the team. So that claim was just dead on the water simply because 2 girls had been allowed on the team before. So I find this case very, very interesting because they applied the McDonnell-Douglas analysis. I wonder if this is going to happen more in future cases that involve discrimination in schools. And I think it'll be interesting to see if it does. Next slide. Okay. So now we're going to talk about, and I referenced this a little bit yesterday in the Q&A. I wanted to give everybody a little bit of an update about some of the litigation that's been going on related to some of the executive orders, federal guidance, dear colleague letters that we've all been seeing going on in the media. And this is stuff that changes. I might be giving you wrong information today when I was working on this yesterday. So, we'll do our best. But if there's anything that anybody catches that's outdated, please let me know because this stuff changes at the speed of light right now. Next slide. Okay, so the first sort of situation I want to talk about is the reduction of force notice that was issued by the U.S. Department of Education back in March of 2025. And we all know this as the order that caused 7 of the 12 OCR offices to close, including the Cleveland office, which is the office that handled the complaints for both Michigan and Ohio. Right now, in case anybody's not aware, the office that's handling those complaints is the Denver office. So if you have been trying to reach any, if you have an open complaint, you can't reach anybody, it's with the Denver office. If anybody needs some direct contacts there, I do have them. So please feel free to reach out to me if you want them. Their supervising attorney there, I can't remember her name, but she is pretty responsive. And I feel bad for these folks. Every time I email them, they're like, you can tell they're just like underwater. I can't even imagine. Their caseloads are like 500 plus, and it's no excuse for the fact that these complaints are totally basically on hold right now. But I do feel bad for these individual employees who I think are just trying to do their best. So, obviously, OCR, as I think most folks probably know, has historically been responsible for enforcing federal civil rights laws that prohibit discrimination in schools. So that includes Title IX, Title VI, Section 504 claims. I feel like there's one more that I'm missing. And what they have historically done is they've been a place where folks can file complaints if they believe that those laws are being violated by the school. And then OCR will, if they think there's sufficient grounds to believe that there might be a violation, they will initiate an investigation. And ultimately, what normally has happened in the past, if the investigation concludes, which I think we talked a little bit about before, has not. I have an OCR investigation that's been open since 2018. That's my oldest one. So I do want to note, and I think Jess made this point yesterday, that OCR was very, very behind and not very timely already. I spoke with someone, I'm on a listserv with someone who's he was the head of the San Francisco OCR office for a number of years. He's retired now. And he told me that OCR never received any additional appropriations, like no increase in budget in any federal appropriations bill since the Bush 1 administration. So they have been severely underfunded and understaffed for like 2 decades now. So while we are all very frustrated with the additional cuts, I don't want to make it seem like OCR was ever a really effective place to go. But one thing that could happen that I think, a lot of folks at our office have experienced, those of us that have filed OCR complaints, is that one thing they were pretty good at was offering and facilitating mediations. And so we were able to get a fair number of complaints, not all, resolved through the OCR mediation process. And it's nice because it's a free mediation process. And some of their mediators are pretty good. So they're hit or miss. Some of them are good, some of them are okay. But it's a way for our clients to hopefully get some resolution with the school without having to pay out of pocket for a mediator, without having to litigate. Mediation, I haven't seen any mediations happening since January of 2025 is the last time I saw any movement on any mediation. So that's kind of gone. Another thing to note about an OCR complaint, which always made it not an ideal remedy for a lot of people, were really two, was first that you had to file your complaint within 300 days of when the violation occurred. Statutes of limitations in court, in Ohio, it would be 2 years. In Michigan, it would be 3 years. So that window was always shorter for folks. So sometimes they wouldn't realize, if you realize if you think a year later, I want to file a complaint, that was always going to be too late for OCR. The other thing was that OCR never had the jurisdiction or authority to award any sort of damages at all. So they could not, if let's say a parent came and said, I had to stay home for a year. I lost a year of income because I had to homeschool my child because the school wasn't giving me what I needed. OCR would never have had the authority to compensate that person for that. Occasionally, I've had a few cases where in mediation, we were able to get some compensation. In mediation, we were able to get compensatory education. I had a case one time where a parent was being forced to travel with her student to out-of-state field trips, and she had to pay for a hotel and her food and that sort of stuff. And so we actually were, through mediation, able to get her compensation for those out-of-pocket costs. But if the case were to go to an investigation, the only thing that OCR would have the authority to do would be to do forward-looking, proactive changes to enforce changes for the school. So things like changing policies, training staff, adding additional staff, ongoing enforcement and oversight, those kinds of things. The one other thing that they could do, not a fine, remove all federal funding entirely to the school. They've never had the authority to fine. They only had the authority to completely cut federal funding. And I think that might have happened one time ever, if it happened at all. So it was never, I just want to make sure everybody understands, it was never that great to go to OCR. If you had a case where you thought you might be able to get something through mediation, that was usually a situation that might be helpful, but that was about it. So let's go to the next slide. So after the reduction of force, then the first round, the March round, because there was also a second round in October of reduction in force notices were issued. Several parents, along with the Victims' Rights Law Center, filed litigation, essentially seeking what's called injunctive relief, meaning seeking an order from the court to prohibit OCR from moving forward, well, the Department of Education from moving forward with this reduction of force to force them to bring employees back and reopen the offices. And their argument was that essentially this is the only way for many, as limited as the relief may be, this is the only way for many families to seek relief from discrimination and harassment, because lots of families don't have the money to file lawsuits, right? And so that this, therefore, was a violation of the students' rights under Title IX, Title VII, et cetera. And fun fact, we have had two of our AW families involved as plaintiffs in this litigation, and one of them remains a plaintiff in the litigation. So we are super excited about that. So initially, when the case was filed initially in the district court in Massachusetts, the preliminary injunction was granted, so staff were supposed to be restored. And that sort of started. And then in September, after the government appealed to the First Circuit, that order was stayed. So the reduction in force is back on as of September. So lots of back and forth. Next slide. So right now, the litigation is ongoing. And what I know from my discussions with my client who's involved in it is they're in the process of negotiating a resolution. I don't know what that's going to look like. The Government Accountability Office, this was really interesting. They issued a report in January of 2026, looking into exactly like what were the effects of this reduction in force. And so the information they received was that in just the 6-month window from March to September of 2025, OCR received more than 9,000 complaints of discrimination. So we're not talking about any of the many, many thousands of complaints that they already had open, like my complaint from 2018 that's sitting on somebody's desk somewhere. And that of those 9,000 that they received in that 6-month window, they resolved more than 7,000 of them. Now, resolved means they closed 90% of them. So they got the complaint, looked at it, dismissed it. So that tells you what's going on there. These complaints are not going anywhere. As of early January, the Department of Education had actually rescinded the reduction in force notices. There was some statement made about like, oh, well, this was never meant to be permanent. This was just meant to try and reduce costs, which again, if you look at that GAO report, no costs were reduced. It's very interesting. But the problem at that point is that you've got folks that were laid off, some of them almost a year ago. They had to find new jobs, right? Like they were still getting paid during that time, but they don't know how long that's going to last. You know, they've got professional aspirations. They don't want to sit at home and do nothing. They also, a lot of them, I think, went into the work because they were legitimately interested in promoting civil rights. And here they are now with, you know, really no work available to them. So we don't know how many of those people returned, but I know just anecdotally from some of the OCR investigators that I interacted with from the Cleveland office, all of the ones that I know of have found new jobs. They're no longer at OCR. And the 7 offices remain closed to this day. Next slide. I've got a couple other, I know we're running short on time, so I'll just hit on these really, really quickly. As we know, there were some executive orders that focused on the elimination of diversity, equity, and inclusion practices, particularly in higher ed. And that led to litigation. Let's go to the next slide. The executive orders essentially were trying to force schools to refuse to. Okay, I got to take my time. I've got to. That were forcing schools to not use any sort of diversity or equity based practices and close DEI offices. We saw that a lot. There was also, I know in Ohio, there was a state law, I believe, that also had the same effect of forcing schools to reduce their DEI. I have a lot of thoughts on that. That law, Ruth and I did a presentation about that earlier this year, and there are some interesting loopholes that I actually think create obligations for DEI that I don't think, because the legislation was written so quickly, people realized, which don't have time to talk about today, but it's very interesting. And one of the main things was requiring schools to terminate equity-related grants. As soon as that happened, a lot of litigation was filed. And let's go to the next slide, and I'll talk about the two main lawsuits. So there's this association. It's called the National Association of Diversity Officers in Higher Education. NADAHE is how they say their acronym. This is an association of DEI officers, right? So across the country, DEI officers, form this national association to support each other, educate each other, that sort of thing. So they filed this lawsuit. It's very, very interesting, alleging essentially that they First Amendment violations, first of all, which I think is really interesting and creative, because their speech and their actions are being limited. Fifth Amendment violations, I can't remember off the top of the head what they were. And similar to the Victims' Rights Law Center lawsuit, there was initially a preliminary injunction issued. The case was appealed to the Fourth Circuit. The injunction was vacated. Right now, that lawsuit is pending. There was another executive order that was issued in 2026, and so they filed another lawsuit. That one is also pending. So there's no resolution on these two. Next slide. Okay. Last one I wanted to touch on. This is the good news, right? Sort of. There was also a Department of Education Dear Colleague letter that was issued in February of 2025. And so it was essentially issuing, that was the one that we saw schools all across the country freaking out about, whether they freaked out to comply, or a number of institutions, which I am proud to say my alma mater, Michigan State University, was one of them, issued an open letter and said, no way, we're not complying with this Dear Colleague letter. Dear Colleague letters are guidance. They are not required. Schools do not have to follow them. And so lawsuits were filed. Ultimately, in this particular one, I don't know the rationale. The government actually withdrew its appeal, and the Dear Colleague letter has been rescinded. So the Dear Colleague letter was then permanently vacated under the Administrative Procedures Act, and there's no further appeal pending of that one. But that does not mean these efforts are over. That just means one battle of many was won. So we have reached the end of my presentation. I know that was a lot of information, so let's get to questions if anybody has any. Oh, and I have a speaker reminder that was put at the beginning that I missed. So I'm going to give you my speaker reminder now at the end. I am a white woman. I have glasses and dark hair. I'm wearing a gray jacket. I work at Abdnour Weicker. I'm located in East Lansing, Michigan. I primarily handle litigation related to students and educators as well as employees. I do have an employment caseload. Relax, smile, and have fun. I did that. So I will check off those boxes. So I don't see any questions from anybody in here. But does anybody have any? Does anybody have any they want to throw in? Otherwise, we can just hop to the break.
Hi, Liz. This is Nicole.
Hey.
We did just get a couple in the Q&A.
Oh, okay. I'm looking at the chat. I'm looking at
No,
the
it's
wrong thing.
okay.
Okay, got it. Thanks.
The first question is, what issue do you think is going to be the next hot topic in student rights law?
Wow. Yeah. Gosh, that is a good one. Let me think. What do I think will be the next hot topic? I think there's going to be, I mean, nobody's really aware yet, because we had a lot of questions yesterday about like, what the heck are we supposed to do if there's no OCR? What are our remedies? Nobody knows. And if anybody who spends any time with me knows that I spend way too much time talking. I'll like get on the elevator and try to talk to people about Cummings, about like, do you know that you have absolutely no recourse if your child gets raped at school? And so I think it's taking some time, but I think as people start trying to pursue civil rights remedies, it really like, because it takes some time, right? I think that when people start realizing how limited their civil rights remedies are, that's going to be a big issue. I also think that states are, and states are already doing this, that we're going to be shifting from a framework of trying to seek remedies for our civil rights through the federal law, and we're going to start proceeding with trying to seek civil rights remedies through state law. And so, for example, you've heard already, both from Jacqueline and from Mitch, some of the serious challenges that we have in enforcing special education rights under IDEA, and also disability rights under the ADA and Section 504 in the Sixth Circuit. And so one of the things we've discussed internally is bringing some of those cases and appeals into state court. Now, I hate state court. I won't get into all the reasons, but the biggest reason is because nothing is online in Michigan. It's like a nightmare. They have to mail you stuff, and they like lose your return envelope and stuff like that. But I do think that we have a possibility. I think we've got to try other places to see if other judges will have a more, you know, reasoned approach to what the law actually says about student rights in disability discrimination and special ed cases. And so I think the idea of seeking remedies from states is going to become more prominent.
Thank you. We just have another question from a participant. I work in a medical legal partnership program in Ohio where we are designed to provide limited representation. A great deal of what we do is advice only. We may, in some egregious situations, file state complaints or due process complaints, but we cannot litigate on behalf of our clients. Given that restriction, the question is, if a case is about ADA or 504 enforcement, and OCR is not a realistic source of relief, what advice should be given to a parent? Most of the clients are not able to afford private attorneys in litigation, but it sounds like that is really their only option, hire a private attorney. So is there a way for them to find pro bono or lower cost representation?
In Ohio, and somebody in Ohio is probably going to have to speak to this for me better. Now, I did work at the Legal Aid Society of Cincinnati for 8 years, but that was a while ago. The legal aids in Ohio generally have special ed units and can help. In Michigan, we do not have that. It's a desert up here for low income families who need help. But in Ohio, most of the legal aid offices do have special ed units. What specifically those special ed units do is going to be on an office by office basis, but that would be my thought on a first place to start would be and now if this person's with the medical legal partnership, they might already be working with the legal aid office and already know what that legal aid office is and isn't able to do. But that is my only thought. But if anybody in Ohio has additional thoughts, please pipe in. All right. It's a dead zone. Sorry. It's terrible. It's horrible. And funding is getting cut. And again, anybody in the legal aid world, I could give probably a 3 hour speech on um, the very limited abilities of LSC funded organizations to help with any sort of systemic litigation. Disability Rights Ohio, I don't know how much they're able to do. I know the P&A organizations are facing significant challenges with funding. I know our Michigan disability rights, Michigan is, having significant challenges and isn't taking on, I don't think, any litigation like this right now. But in the past, those would be places to go. But we're in a really tough situation here. It's really tough.
All right. Thank you, Liz, so much for answering all those questions today. I know we have a couple more in there, but I think we have one more and just a response from our person that asked that last question. Just, thank you. And they tried legal aid orgs, but they agree it's never enough. And that's part of why we're having this conference today, to spread the awareness and get more people involved and hopefully get more attorneys involved on this side as well. So thank you, Liz, so much for such an informative update of all the new student rights cases going on. We are going to take a break now until 10:10 a.m. And we will be back at that time for our next presentation, and we will see you all shortly. And just one more thing, Elizabeth did drop the link to the evaluation in the chat box. So if you could please fill out that session 1 evaluation, that would be great. Thank you all, and see you at 10:10.